Sure. My name is Jeff Stinson. I have been working in the areas of elder and special needs law since the late 90s, 1998. Started my own firm a few years ago, but worked as an associate for another attorney for a number of years. And essentially, my work involves one of two aspects. I'm either working with families who are in need of long-term care, usually elderly individuals needing some sort of long-term care, or I'm working with families that have a child with special needs and helping through all of those legal issues, including public benefits planning, because that's where my bread and butter lies, are public benefits eligibility issues, how to overcome barriers to eligibility, protect assets, supplement that care. So we're going to talk a lot about those issues today. I love questions, so don't hesitate to stop me and ask a question. Let me start with just a general question for the audience. What are your pressing questions? Is there anything any topic that you hope I'll cover today? Because I might add some emphasis on a particular area of what I'm going to talk about today if I know someone's particularly interested.
Mostly guardianship.
Okay.
Guardianship too. Yeah.
Guardianship. Okay. Very good. Very good. We'll talk quite a bit about guardianship. Any other topics? Okay. Great. Well, I tailored this presentation specifically based upon a need within my firm. We've got a lot of calls from long-time clients who are asking me, my child is transitioning from juvenile to adult. He or she is reaching that magic age of 18 years old. And what should I be concerned about? What should I know about that's going to come up for my child? And so I got to thinking about it and kind of put these things into, four issues, but the fifth is kind of a little sub-issue that parents need to consider as well. We'll go through each one of these in detail. The first being financial support and medical coverage. Public benefits tend to arise, the need arises, eligibility arises when your child turns 18. The reason being is when a child turns 18, there's new eligibility criteria. How many are familiar with SSI, for example? Okay, we'll talk about that. Medicaid. These public benefits programs that, one, maybe the individual did not qualify when they were under the age of 18. The reason being mom and dad's assets and income were part of the eligibility criteria, and mom and dad had too many assets or too much in income, so the child didn't qualify. Well, when the person turns 18, he or she then has their own eligibility criteria. Mom and dad's assets, income, and even siblings, I forgot to mention them. None of their assets or income are part of that eligibility process. Also, there's new disability criteria when a person turns 18. Prior to age 18, the criteria for SSI, for example, I need to explain what that means here, is a little more stringent, I think, than when you become an adult. The adult standard is, are you able to work substantial gainful activity? And they have different definitions and sub-criteria what that means. But the disability standard is different. Also, we're going to talk about this. You might say, well, fine, but mom and dad's income assets fall off the table, but my child still has $50,000 that her grandma left them, put in the bank for them to use through the rest of their life. And we'll talk about ways that you can protect that money and access the public benefits through this vehicle called a special needs trust. We'll talk about public benefits programs for a minute. There's a number of programs, two which absolutely have nothing to do with financial eligibility, and that's Social Security, or specifically Social Security disability benefits, and Medicare. If an individual is disabled and that disability started before age 26, if a parent has retired or has passed he or she will receive Social Security disability benefits. Similarly, if someone becomes disabled and has a work history, they can receive Social Security disability benefits. But most often, with the newly adult child, one thing to be cognizant of is if mom or dad, if you're getting ready to retire, or if mom and dad, one of the parents have passed away, the child would qualify for Social Security disability benefits. In addition, Medicare, which is a federal insurance program, most are familiar with Medicare as a health insurance program for the elderly over the age of 65. However, if I'm disabled by Social Security standard for a period of 2 years, then I receive Medicare. So the newly adult disabled child may not only qualify for Social Security disability, but will also get Medicare health insurance. Okay, SSI. I threw that acronym out there. SSI is a federal program administered by the Social Security Administration. Different from Social Security disability. SSI is designed to ensure that a disabled individual has at least enough subsistence to pay for their food and shelter. Now, we can we can be real clear that what they provide never really is enough, but it is something. The max benefit is $733 for year 2015. It's different from Social Security disability. SSI is a needs-based program. You have to meet a certain asset and income level in order to qualify. In addition, the recipient must be blind or disabled. Now, again, let me refer back to what I said earlier. When the person turns 18, there's new eligibility criteria. Mom and dad's asset and income information are no longer part of the eligibility process. So the individual would be eligible for SSI if he or she has assets less than $2,000 and income less than $733.
Can I just clarify on the 733, is that a max like for all types of benefits? So if the person was receiving disability and say their benefit was $800,
okay,
would that mean they would not qualify for SSI?
That's right. That's right.
Okay.
Now, the opposite, though, if they were receiving $400 of Social Security disability, they could get $333 in SSI to get to the 733. For individuals that, some children do receive SSI because mom and dad's income and assets are so low and they've been determined disabled by Social Security Administration. Well, Social Security will reevaluate the child at age 18. If anyone's in that situation or going to be in that situation, know this. When that disability reevaluation occurs, you don't have to use the agency's supplied medical staff to conduct the disability evaluation. Matter of fact, I recommend against it. You can use your own doctor, use the child's own doctor, own medical assessment, own medical providers to make that assessment. The reason why I say that is they're not supposed to be, but I see a lot of biased opinions coming from administration-provided medical providers. As an example, I was aghast a few years ago when a longtime client of mine, he had SSI, he turned 18, lost SSI because when he was being reevaluated as an adult, Social Security sent him to a particular psychiatrist who basically come back with the opinion that even though he had a traumatic brain injury, he was making most of this up. And so we appealed, we went back, got a second opinion from a couple other second and third opinion from some other medical providers and prevailed, but that was something we probably could have curtailed if we just would have went to his mom would have went to his medical provider to begin with. Something to remember. Medicaid for the disabled. Now, Medicaid is an insurance program for those who qualify. Provides assistance with health care. In addition, Medicaid waivers, these are additions to the traditional Medicaid program, can provide help with housing, life skills, vocation skills, basically help the individual to live in a community setting and avoid an institutional placement. Some children do receive waivers. Unfortunately, a lot of the waivers have a extremely long wait list. So here's another tip for you. If you haven't already done so, contact your local Bureau of Developmental Disabilities or the local Aged and Disabled Agency, which is SACOA for this area, and see what waivers your child might be eligible for and get them on the wait list. Some of these wait lists are 14 years. And so at least maybe you have things covered through these younger years. As your child ages, your spot will come up on the wait list and we'll start getting those services as an adult. Okay. The eligibility criteria is a little different for a waiver. Traditional Medicaid, when it's a child under the age of 18, mom, dad's income and assets are lumped in for eligibility. Just like SSI, over age 18, we just look at the child's income and assets. However, if the child's receiving a waiver under age and is under age 18, then we use the adult rules. So the child, only the child's income and assets are determined into the eligibility criteria. Okay? Now there is an income cap for Medicaid for the disabled. It's $981 unless you qualify for a waiver or other long-term care services, and then it's $21.99. We're going to talk about if someone has income over this $21.99 and they are in need of long-term care services, a technique to get around the income cap. Other criteria for Medicaid for the disabled. We also have to meet the definition of disability. Usually this is the definition as required by the Social Security Administration. Indiana last year, after decades of a different policy, decided they're going to follow exactly what the Social Security Administration says. So if an individual wants Medicaid, they have to go to Social Security first to get a disability determination. There are a few exceptions where Indiana will still have to determine disability, but most often they're relying on what the Social Security Administration says. And then there's also a little program called MedWorks that is for working individuals with disabilities. Much more liberal resource and income requirements, so you don't have to be down to those low thresholds. They allow you to keep, there's a higher asset threshold, and they allow you to keep more of your assets. There's certain assets, for example, they're excluded, right? Certain retirement accounts are excluded that aren't under other programs. So this is a way for an individual to work and still receive some health coverage through Medicaid by buying in. Basically, you pay a little premium, health insurance premium to the Medicaid program. Quickly, a few other programs. Federal assisted housing. Most often this is rental assistance. There is an income limit. There's no asset limit, but there is an income limit. And obviously, if the child is only receiving SSI or most often just receiving Social Security disability, they're not over the income limit. And then food stamps that obviously provides nutritious food. It has an asset and income limit as well. All right, I told you what we talk about what happens when there are too many resources, when the child has too many resources. So you're at age 18, there's that little account that's been accumulating that has $30,000 in it from family gifts or grandma, grandpa, whatever that might be. Obviously, you're over the $2,000 resource limit. Well, what can be done? Well, one tool is to simply place those funds in what's called a special needs trust. Now, trust is nothing more than a holding tank. We're going to put things into the trust, but it's just a basket that holds. It can hold a CD, it can hold a bank account, it can hold stocks, it can hold real estate. Any number of things are in that holding tank. And then the trustee is the person who's in charge of what's in the holding tank. And a special needs trust says, this is for the disabled individual, but the trustee determines when and how distributions are made for the disabled individual. And as a result, discretionary standard, as a result, public benefits programs do not count what's in the trust. The trust corpus, what you put in there, doesn't affect public benefits eligibility. So even though there's a $2,000 resource standard for SSI or Medicaid, I can have $100,000 in the special needs trust, and it doesn't affect my eligibility.
You have reached your destination.
It allows you to use the assets in the trust for things that Medicaid or SSI does not pay for. And we'll go through kind of a list of those things towards the end of the presentation. Now there's two types of these special needs trusts. One's a self-settled. That's where the example I've been using. The child actually has too much money and they need to set up their own special needs trust. There's also a third party. And this is that little sub-issue that I listed at the very beginning about mom and dad's estate plan. And I'll talk more about how that fits in as we move along here. All right, the self-settled, the one that's created for the child's money. It holds assets that were formerly theirs. Child sets it, the child's the beneficiary. It's always created during the child's lifetime. And like I said, it protects a windfall. I actually work with a lot of disabled individuals that have received a settlement or an inheritance, and we're working to protect that. You know, that $250,000 settlement, which obviously isn't going to cover all of their needs for a year, much less the rest of their life. So we're working to put this into the special needs trust so that it's there to supplement their public benefits. It keeps their public benefits in place, and then they also have this extra congressionally supported windfall to help supplement that care. Three types of self-settled trust. I'm going to go through these real quickly. There's the self-settled trust, which the child creates their own document. The parent actually creates it for them, but there's this own individualized plan for the beneficiary. There's the income trust. This, as I talked about earlier, I talked about income cap of $21.99. Well, an individual can create an income trust and put their excess income in the income trust in order to qualify for a benefit. And then there's a pool trust. If anyone's familiar with the Arc of Indiana, there's also two other pool trusts that serve Indiana: Special Needs Integrity, the National Foundation for Special Needs Integrity, and I believe it's Life Streams or Lifespan that's up in the Chicago region. What they do is they kind of use the efficiencies of several account holders. There's one master special needs trust, and each beneficiary has an account under the special needs trust. And as a result, it's not as expensive to administer. Usually folks that have smaller amounts, $10,000 that they need some place to place, they'll use a pooled funds trust. The self-settled trust, there are trade-offs here. Congress in the mid-90s said we want disabled individuals to have this windfall, but there's a trade-off. You put the money in, first of all, you have to follow our criteria. It has to be specifically follow these rules for its creation. And it has to be for someone who's disabled. And if there's anything left in that trust, self-settled trust, the state gets paid back first. So if the state's paid Medicaid $100,000 during the child's lifetime, the state gets the first $100,000 out of the trust if there's anything left in it. Now the goal with the special needs trust is we have a life care plan where that last dollar is going out on that last day and there's nothing for recovery. I'm going to skip this. We talked about the income trust is used to get over the income cap. And then the pool trust, again, that's several accounts for one beneficiary. All right. Other potential medical coverage, parents' health coverage. Even before we had the Affordable Care Act, a lot of parents' plans allowed children with disabilities to be covered under the parents' plan for an extended period of time. We talked about Medicare kicks in with Social Security disability after 2 years. We now have HIP 2.0, and I noticed just today that there seems to be a lot of extra media attention, especially on the radio, about HIP 2.0, which is a health insurance program that's designed to fit people who don't have affordable employer-provided coverage but don't qualify for Medicaid. Kind of absorbs those folks in the middle. And then there's still private insurance under the exchange. An individual may not have been insurable before the Affordable Care Act. Now some of these all of these pre-existing conditions have been wiped out, so you automatically qualify under the exchange. All right. Guardianship. I know a lot of you were interested in guardianship, so we're going to spend some extra time here. Some folks are surprised to learn, and I don't. It shouldn't be surprising, but under Indiana law and most state laws, when you reach the age of majority, when you reach age 18, you are determined to be your own person, to be able to make your own decisions, do whatever you want. So even if someone, I went through this today with a client who said, well, mom's kind of the antithesis here, but mom has severe dementia. She has said she has a living will that says, give me a feeding tube, but today she said no feeding tube. Well, what do we do here? And I said, well, you follow what mom says, because until a court determines she's incapacitated, she has her own capacity, she's her own person. It doesn't matter what her diagnosed disabilities is. The legal system has to determine someone is disabled. So typically, what we're talking about is guardianship. Now, we're going to talk about alternatives for decision making, but I'm going to hit on guardianship for a while here. Now, guardianship, it's a legal proceeding. We go to court, we petition the court for a determination of incapacity, and we petition the court for the appointment of a guardian. A judge is making this decision. So the court first has to find the person is an incapacitated person under the law. Is there a diagnosed disability? That's not all, though. Is this person extremely susceptible to others' influence? Is this person habitual drug abuse or alcoholism? That can be determined incapacity. So that's the first step. File a petition with the court. The court sets it for a hearing. The individual gets notice that this person has filed a petition for guardianship. The doctor is requested to issue a statement, give a report to the court on the individual's incapacity. That's typically the evidence. Sometimes we need more than that, but that's the typical evidence to prove incapacity. Then there's a hearing date. We'll usually talk in the hearing date. If it's an uncontested guardianship, we simply introduce the evidence from the doctor. We introduce mom or dad, whoever's petitioning, will come up and say a few words, and usually the court wants to hear from the disabled individual. So what the judge is doing is finding incapacity, looking at the medical evidence, and also determining who's the suitable guardian. Now, requests of family members are usually given extreme deference. So if it's mom or dad, obviously that's kind of where the judge is going to go. But even if mom and dad are gone, we'll talk about mom and dad's estate plan, the judge kind of takes what mom and dad has asked as gospel. If mom and dad says, if we're both unable to serve as guardian, we want Mr. Jones's sister to serve as guardian. And as long as Mr. Jones's sister's willing, the judge usually takes that into account. It has to be real extreme circumstance of the sister having something in her background where the judge says, no, we're not going to do that. Now, there are different types of guardianships. It all relates back to the powers that are needed or given. A guardian of the person works with the individual, or works for the individual, consenting to medical treatment, things like consenting marriage, living arrangements, medical treatment and living arrangements being the most primary issues there. So the guardian of the person wouldn't have the authority to manage the bank account, but the guardian of the person would be determining, yes, we're going to do this medical treatment, we're going to enroll in this program, we're going to discharge from this facility and admit to this facility. The individual is going to live in this arrangement. That's what the guardian of the person is doing. Guardian on the estate, on the other hand, is managing finances. Now, the same person can do both. It's really just what powers, what authority is needed. So the guardian of the estate is paying bills, managing the checking account, doing those things on an everyday basis that the individual needs. The powers can be broad or limited. We can say, Judge, we're looking for all of the authority that you were able to bestow upon the guardian so that the guardian has a might be overly broad, but the guardian is able to do anything that might come up for this person for the rest of their life. Or it can be limited. And limited can be key here, especially for a parent who's wanting to try to bring some level of independence to their child. So you can limit, you can say, we're not going to take everything away from you, but I am going to be there to oversee your medical care. I'm going to maybe defer to you, but I'm going to be the one kind of guiding the overall care plan. Or as large as the finances, I'm going to manage most of your finances, but we're going to give you a checking account with a couple $100, and I'll keep replenishing that. And you're in charge of that. I don't have any authority over that. So we can really work with the provisions to come up with a plan that doesn't totally take all the legal rights away from the individual. We've already talked about this. The adult is presumed to be able to make his or her own decisions unless the court has found otherwise. A lot of folks will ask me, well, do I really need a guardianship? You know, my child gets along fine. No one's really stopped me. I mean, my child's 22 now, and I've never had a doctor say they're not going to talk to me, and my child follows what I say and participates. And maybe not. Maybe you don't need a guardianship in that circumstance. But I will tell you this, especially down here, if your child's susceptible to the influence of others, you know, the door-to-door salesman or I won't pick one particular company, but the satellite guy that comes in and says, you need this satellite, they signed the 2-3 year contract. Well, without a guardianship, they have the capacity to contract, and they're locked into that contract. Whereas if you had a guardianship, it doesn't matter. The salesman could come in, they could put pen to paper. You call the salesman later and say, listen, you just took advantage of somebody that's under guardianship. This contract is void, and that's the end of the story. So that's a big thing there. Also, the ability to make gifts. I do see this more so with elderly individuals than my disabled clients that are talked into, but sometimes not even talked into. They get bombarded with all these requests through the mail for this charity and that charity and that charity, and they sign a $10 check there and a $5 check there. Eventually start adding things up, and goes, boy, mom and dad have given away 10 grand in a year. So there's another circumstance where guardianship could avoid being taken advantage of, or just giving away things they shouldn't. Or if your child is particularly gratuitous. I know my son, he gave you the shirt off your back if we asked him. So that is something that a guardianship can help avoid. If you think your child's going to fall into one of these issues, then it's probably a good thing to petition for guardianship as soon as they turn 18. And you might even start preparing for that shortly before their 18th birthday. Now, we don't want a ruling from the judge before age 18 because it's going to do no good. But it'd be nice to have the pleadings in place, the documents in place, so that we can file and get a hearing date right about the 18th birthday. That'll eliminate these issues. And one thing that does come up every once in a while, we do get a doctor when he turns 18 where the son says, I don't want to hear mom hear what I want to say about my medical, and the doctor has to say you got to leave the room. Doesn't happen a lot, but sometimes I have parents when their child turns 18, those IEPs with the school, son, daughter says, I don't want mom or dad here. They can take mom or dad and excuse them. So the guardianship kind of makes sure that mom or dad can still have a seat at the table. Temporary guardianships can be made in extreme emergency. If you have a plan for that 18th birthday, well, 18 arises, and I don't know, if son says I'm moving out the day I turn 18, and it's just no way conceivable that son can live independently, we can get a temporary guardianship to protect them so that they're not out. And that can kind of bridge the gap between a permanent hearing and a need for an emergency. Okay. Questions about guardianship?
So how long, like, that whole process, I mean, it takes, because like my daughter will be 18 in August. My
Okay.
son is 18 next year.
Okay.
And they're both, I don't have faith in either of them making decisions as an adult. So, and, you know, my son's a little bit more aware that he just has no interest in making any decisions right now. So it's kind of like, you know, how would I get that? Plus, it's like I haven't had much luck with it. Government agencies are always down my back and everything, and accusing me of stuff. And it's like, okay, I've tried to raise these kids and they're getting in my way.
I'll start by answering your question with, it depends. And it depends on what county, first of all, you live in. The guardianship process always goes back to the judge's calendar, the court's calendar. Marion County, from the day you file a petition for guardianship and the date of the hearing, it might be 60 days. Hamilton County, it might be 30 days. Some counties don't follow the procedure and might sign your petition the day you bring it to the court. I've been on the opposite of that, but it's not good. But that's kind of, to answer your, to be more specific with your question, it's probably early July, you probably want to start getting things lined up. Because you do have to get the physician's report with the medical evidence ready and getting out to the doctors and the doctor can fill it out. So, any questions?
Do mom and dad usually both become equal guardians?
Can, yeah.
And if you were need to sign something as their guardian, would both people have to sign it?
Good question. If you are co-guardians, you are able to delegate authority between each other. So you can say, this person's going to handle the checking account, so I'm delegating that authority to you.
But that has to be decided at the time of guardianship, or is that just how it works?
The court appoints you as co-guardian. Well, let me step back a minute. The court could say this person's in charge of personal decisions and this person's in charge of financial decisions, but they don't cross over. That's okay. Or the court could say, we're going to put these two in the saddle and they're going to be in charge of both here and here. So the problem arises, I'm going to use the checking account issue. You go to the bank and the bank says, okay, there's two guardians here. And the bank says, we're not going to do this because we don't want the liability ensuring that there's two signatures on every check and so on. Well, outside the court's purview, the guardians have the authority to delegate these tasks between each other. So the one guardian files a power of attorney and says, I'm delegating this to this person. So this person handles the checking account, for example. So that's a practical way to kind of fix that situation. The real humdinger comes from medical decisions, and if you don't delegate between each other and there's an emergency, I mean, it's just like parents, there's an emergency, somebody has to make a decision, the doctor says, well, we want both persons to make these decisions. It'd be good to kind of, if you haven't, they'll sign this person through the court, at least delegate the authority to each other so they make unilateral decisions without both of you being.
How expensive is this process?
Well, I can only speak from my office, and petitioning for guardianship and getting guardianship in place. And you, Bishop, it's a real good question. I average about $2,000 for the process. If there is a guardian of the estate, you have regular responsibilities to the court. You have to tell the court every 2 years, every dollar that you have gathered for your child and every dollar you've spent for your child, penny you've spent for your child. And so there's ongoing fees with the administration of the guardianship. And the accounting time depends on client, but I'd say it's probably $750 every time we do an accounting cycle. So there are ongoing expenses involved. There's also court costs. They're nominal compared to the attorney's fees, but there are also court costs involved to establish the guardianship. I don't know what other offices do, but that's the guardian, the person also requires a biannual report. You can get away with getting the attorney, hire the attorney, get the guardianship established, and then you don't have to go back for legal assistance to file that report. or most courts give you a little form. Basically, the court wants to maintain contact. The court's bestowed this authority. The court wants to make sure that you're doing your job. So the court wants to know, is this person, where's this person now living? What's their education? What's their work? And they'll want that report every 2 years. But most courts will provide that for you, so you don't have to get your attorney to put that together every time. Now, there are alternatives to guardianship, and this would be the situation. One, if your child has capacity, legal capacity. The standard basically is, does this person understand the nature of what they're signing? Do they understand that if I'm signing a financial power of attorney, I'm giving mom or dad the authority to spend my money and collect my income? If they can understand that, it doesn't matter their diagnosis. As long as they can understand that, they can sign the power of attorney, and you, from a practical standpoint, you're doing the same things that the guardianship would be doing. Likewise with healthcare advance directives, if they can understand the nature of, I'm appointing mom to make healthcare decisions for me, well then, that's something else that can be done, as long as they understand the nature of what they're doing. Only caveat, child is the boss. So you might be the healthcare representative, but they're making a point where the child says, I don't want you in here, mom. I don't care if you're healthcare representative or not. Or, you're fired, mom. I don't want you to do this anymore. I'm revoking this. So that's the caveat. And it also doesn't, financial power of attorney doesn't protect the child from themselves. Again, if they're susceptible to the influence of others, or easily walk into signing a contract, things like that, power of attorney is not going to help with that because they still have a legal capacity. So these are good practical alternatives. I'll tell you, most folks will do this if the child has capacity versus the guardianship, because it's cheaper, and they know, yeah, I know, my son could do these things, but it's pretty unlikely they will. Questions? Yes.
Not to get too off subject, but for example, I have a good friend. Well, first of all, we have 2 children that are autistic, so this is important to me personally. But I have a friend who later found out after her marriage that her husband was possibly on the spectrum. And once they get older, let's say something like this happened with the child, and then they either, like in this situation, he said, choose not to receive that help anymore. Or what happens, because we're all adults and I feel comfortable, like if an adult, might need help, and legally what would the process be like that? Like for my friend, for example. She found out after they had 1 and 2, their second child, that with the changes and stuff, it was just too hard for her husband to deal with.
Very well similar to what we're talking about here with the teenager becoming an adult. I kind of can relate to that because most of my work are involved with families who mom and dad suddenly, because of dementia or some other debilitating illness, can't take care of their own financial affairs. And many of those circumstances, I've been doing this for 50, 60, 70 years. There ain't no way you are going to help me at all. So we have to get the guardianship, because there is no volunteering to say, I'm going to appoint this person. Now, most folks have these directives in place. So in your friend's situation, if her husband's willing, you can simply, I'm assuming that he's been around this long with the potential diagnosis, and that he understands the nature of this is a power of attorney. So he could just give her the authority, so long as he's willing to.
Agreeable to it. Right.
It's a real practical, inexpensive way to handle that situation. Now, if things progress, now I understand the reason why. I had a client who, in his 50s, he was a well-respected doctor, but developed, I don't know what, I can't remember the particular illness, but the straw that broke the camel's back was he would go into these manic phases, and he ended up buying 125 digital cameras within a 3-week period. And that's where his wife said, no, that's where we petitioned for guardianship. His wife said, no, we can't do this anymore. And he actually supported the guardianship, but we actually did a limited guardianship, because we still said, well, you're going to have your own, spending money, but you're not going to have access to this, and we're certainly going to give you a credit card and things like that. So there's different ways to cover it.
Okay.
I'm actually here for a friend, and she has a 16-year-old. They're looking into the guardianship, and there's a medical issue that she's going through right now that might require, or that mom and doctor kind of want to do a surgery that's an elective. Is there like any reason why she should try to do it before or after 18? Is it easier one way or the other?
Well,
It's a hysterectomy.
that's a good question. Well, first of all, without a guardianship, once the daughter turns age 18, she says no.
She can't say no. Like she won't
Okay.
be able to.
All right. After age 18, let me say, it depends on the procedure. I know you said elective, but if it's...
Well, it's a hysterectomy,
Okay.
and they've tried all these other things, and so it's not like medically necessary, but it would help her daily life.
Surgeries such as that interfere with reproduction, it could be a little hairier after age 18, even if there's a guardianship involved.
Okay. Either way, they'll probably go through a court process.
Prior to, probably not.
Okay.
Parent consenting for their natural child.
Okay.
Afterwards, though, it's yes, the guardian has authority to make medical decisions. Our courts have kind of interpreted, does interference with reproductive rights, is that a medical decision? They've kind of went both ways.
Right.
My most recent experience with that, we had a child that turned 18, was become very popular real quickly in the community, and so guardian, we got a guardianship, and then there was a real tough case on, does the guardian really have the right to enforce birth control on this child? And, the judge found for us after, but we had to brief it, and there was quite a few cases going back and forth both ways on the issue. So I think a hysterectomy could be kind of...
Oh, it's a big step.
That's a
and
big
it's
step.
Yeah.
So
It's gonna be
I would say before 18, there's going to be less resistance than after 18. Other questions? All right. A couple other issues we've talked about. What are those financial, medical, financial? Can the child may be able to get some additional cash to help support them through Social Security, SSI, medical, Medicaid, mom and dad's health insurance, decision-making through their own person? Is that a good idea? Is that a bad idea? Or do we need to place some protective arrangements through the guardianship? Then education and work. I don't do individual disability education, IEP, sorry. I just have so much other business. I love to do it. I actually, with my own son, I'm just experiencing that process. So maybe something I'm going to practice later. But what I do know is, under the idea that at age 14, the system is supposed to be gearing the individual for later life skills, employment, further education. So, at age 14 is a good time to start that. A couple other things I wanted to point out that also, these are disability programs under SSI and Social Security Disability. Allows a disabled individual to, if they want to present a plan that I'm going to get here, I'm going to, despite what my limitations might be, I'm going to overcome those, and I'm going to do this by this program. I need this much money to do it, and I need my Social Security disability while I'm going to school, for example. That's what this Ticket to Work program and Plan for Achieving Self-Support. There's similar programs, one's for folks that receive Social Security disability, and one's for folks that receive SSI. I don't want to belabor that too much, but I did want to point those out. Okay, one final issue. Housing. I have lost count of the number of families that I've worked with, even my long-term clients they're now 70 years old and they've had their 50, late 40s, early 50s, disabled child still living with them. And they've been their primary caregiver for all these years, and they've never really thought about what happens now. The earlier you start getting this plan in place, the better. Because just think about, if you weren't able to care, you're the primary caregiver for your child, and if you aren't able to be there for them, what happens then? We don't want a crisis to occur. It's always good to have a plan in place. So be thinking about that contingency plan. Now, even if, I know in the foreseeable future, Charles will live with us until who knows when. That's fine, but have a contingency plan in place that if you're suddenly both debilitated and can't share in and be that primary caregiver, who's going to be next? Looking at different programs, looking at subsidized housing, shared housing arrangements, what's that going to look like? If your child's going to go off to college but still needs some supports, how's that going to happen? So they're 14, 15, it's time to start thinking about those things. Before I get into that, any questions about just how do we make sure that our child's covered when they start moving from juvenile to adult?
Well, how do you go, there's a couple things. One, if you kind of to go back on guardianship too, how does that play with finances as far as their ability to get assistance? Because if you're in charge of their finances, and does that mean that all their finances count, or does that mean your finances count since you're a guardian?
Right. So I think you're referring to like public benefits eligibility.
Yeah.
I'll just pick one program that's kind of the same across the board. SSI, Supplemental Security Income, needs-based program, have to have less than $2,000 in assets, have to have less than $733 in income. Okay. Doesn't matter whether you're managing my money or whether I manage my money, it's my money. So if it's under guardianship and there's $8,000 in the bank, I'm ineligible whether the guardians manage that or not.
Okay, but it's still theirs, and they wouldn't take money, right?
And they would count your income or assets after age 18.
Okay.
Before they can, after they don't. Before they can, except if you have a waiver, then they treat you like an adult and just use your income assets.
And then how do you go about, I guess I've always kind of wondered, because I've been trying to figure out like housing and stuff, and actually my 16-year-old will bring it up every once in a while, but then I'm thinking, where do I go to look for those, where do I go to find out about subsidized housing or shared housing or whatever?
That one's tough. I don't have a lot of experience with funding. Most of my clients have, and what I have is a lot of resources about special kids. I don't know if they have resources to help with finding housing. Obviously, what the government agency is supposed to help with that is the Bureau of Developmental Disabilities. There's a section in different areas of the state. Here in Indianapolis is the closest. They're supposed to have those resources. I know there's also folks in the community that handle that privately. I'm not intimately familiar with that. That's my answer. Any other questions?
My friend wanted me to ask, when the child goes into like a day program instead of like a school where the parents can just come in and visit, does guardianship rights change? Do you know, or does it depend on the day program whether they can just come in freely?
Well, if I'm a guardian, you can't restrict my access to the ward. Sorry, that's the term.
No.
Now, if the child's over age 18,
So kind of
I don't
seen
want
as
mom
a
and dad
parent.
here, then
Gotcha.
from a practical standpoint, is the day program going to limit access? That's one. And if the child says, I'm 18 and I don't want mom and dad here today, well, they might still, but legally, they can say, just wait outside.
Okay.
on the housing side,
Uh-huh.
let's suppose you've got your profoundly disabled kid. He's 18, you want to get him into some kind of housing that's appropriate for him. How do you pay for it?
Well, the autism one, supposedly they give you some sort of like supplemental income based on, and you're saying like with SSI, it's only his income, so we shouldn't be putting anything in a bank account under his name, is what you're saying. 'Cause then they'll-
If it's his money, I mean, you don't want to be making transfers to get his money out of his name. But if the family are giving him money or you're accumulating, you don't want to put that in his name.
Because then they'll take that.
They'll
instead of-
count that as.
Okay.
Well, let's assume we've done that. He's 18, he's never had a job in his life. He's got no money of his own. How do you pay for housing? Obviously, we can't afford full-time nursing care for a child. If we weren't able to take care of him in our house,
Before we're told or something.
what options in housing are available and how do you pay for it?
Well, it really goes back to the waivers. And I think
Okay,
you
we've already got an autism waiver. There's no reason to believe that will disappear at any point, so.
that's really good. That's the start. Do you did they assign a care manager under the waiver?
We have a case manager.
Case
Yes.
manager.
Yeah.
He's not old enough for that.
He's not,
Okay.
he's only 9, we're years away. from
Okay,
this.
very good.
Okay.
So as he gets closer to that time, the care plan is going to change. And the case manager should start working with you in the care plan, moving towards, our goal is, he's going to live
I'm
outside the
concerned
home.
is if this facility has a 10-year wait list, then maybe I should want to keep this down.
Yeah.
There's,
I don't know if that kind of situation exists, but.
I don't know with the housing, I mean, obviously with waivers, earlier the better, as soon as you have a diagnosis, go and get on the waiver. I mean, if he's 9 and he's on an autism waiver,
Yeah, we had him on before age 3, so.
that's
On the wait
standard.
list. Not on the waiver, but on the wait list.
Yeah, it's until 7 until they cleared it.
That's
so.
still pretty.
It's good, because mine was on for 10 years
Yeah.
before he ever got
Yeah.
his. So, yeah.
It's a question, especially really related, or maybe really part of two questions. But let's say that in this shared housing, the way I look at that from a practical standpoint, that maybe there will be a time that in the case of, I have 2 children who are autistic, it seems to me a good strategy to get them ready to live independently. If I eventually sell my house and buy 2 houses side by side, smaller houses, or they can live in one and I can live in the other one, so they can be trained still within this. Now, that's a practical thing that is really about money or finances. But will the access to Medicaid waiver or any kind of assistance be affected by the fact that I'm donating an accommodation for them? How is that perceived by receiving income?
The kind of, interesting sort of question. Under certain programs, let me just one thing at a time. SSI, Supplemental Security Income, I can get up to $733 a month. But if someone else is providing all of my shelter, then they can reduce my SSI benefit by a third. So I get a third less than rent. Now there's a way around that. You could charge him rent. You could take that third back as rent, put it in an account for him, and use that for him as you want to. That's one way around that rule. With Medicaid, the rule is similar, although all they want to see is he's contributing something to the shelter cost. So he might be living in that house for free, but have him pay one of the utility bills out of his Social Security income. Then you're not paying for all of his shelter, and there's no effect on his Medicaid benefit. And so traditional Medicaid then relates to the Medicaid waiver, so there wouldn't be an effect on the waiver benefit either. So that's really the only thing you need to be cognizant of is if he's living in that house for free, SSI could reduce it by a third. Medicaid won't reduce as long as he's contributing $10 to the electric bill, then he's paying for some of his shelter. And then you don't have to worry about that being
the waivers.
Uh-huh.
I'm trying to remember where I read, if I assumption is correct, there's the smaller waiver that our child has now. Then there's a bigger waiver that you get evidently if the child goes into, if the person goes into an extended care facility and then you take him out again.
Well, I don't know if that's the case. There, as you need more services,
Okay.
there's they just reorganized their waivers last year. Cohabilitation and
Yeah.
rehabilitation waiver, I think that's the term. That's the bigger one. That's for community, basically, so you can live in the community outside of the institution.
That's not the one he has.
And there's special rules on where you can get into that. There's not the huge wait list on that we used to have, but I'm not remember
Okay.
Well,
off the top of my head.
we can apply for those
You can't apply for that
until he's
like 18, right?
That's
There are certain conditions that you have to meet because.
I mean, we're not, I just,
But I think.
we don't need to be on the wait
If I
list right now.
remember right, one of those conditions is if you were previously in a Medicaid, take them out, then you can qualify for that way. If they really want them out of the.
Oh, so this is, money follows the person, it's a grant that started a few years ago, and they
Okay.
extended the grant. If I'm in a long-term care facility and I'm receiving Medicaid benefits while I'm in that facility, and then I go home, I think it's 90, I have to be there 90 days, and then I leave and go in the community. Those dollars that I have in the facility follow me to the community, and after a year, I'm supposed to be plugged into one of the waivers. That's how that
And I
works.
think that's how you get into one of the bigger.
Well, we don't need to be on the wait list for the new waiver for when he turns 18 right now, because, he's 9. Because I don't know how that works. I mean, would the case manager just change us over, or?
Well, since they redid the waivers last year, I don't know how they're handling that. What I do know is when they reconstituted the waiver, renamed them, they eliminated the wait list on several of them.
Yeah, that's why that's why he got off it.
Yeah, yeah. I don't know, does anyone else know anything about it?
Okay.
And then the waiver, because they only have like the family splits waiver and then the other waiver, because they combined 3 waivers
They did.
into the smaller,
Right.
into the other waiver, and then they have
That's
the one that
Family
takes
supports.
like,
And
yeah.
then cohability, that's the one that,
Yeah, and then the one that almost nobody qualifies for anymore is that cohability. I mean, that's the one that almost nobody qualifies for anymore, because they also changed the requirements when they did the requirements and got people off the waiting list. And when they did that split and combined them, then, it ended up kind of cutting things in other places, so.
yes. A number of those clients. That was tough,
Yeah.
because on one hand, this family's saying, we've had this for years, and now you're cutting my services. What are we going to do? On the other hand, we have folks that say, well, we've been on a wait list for years, and now we're getting services. So, yeah, that's tough. Okay. I'm sorry, I don't have a off-cuff answer, but see you afterwards, and I'll look at it. Any other questions? Move on to parents' estate plan. Never forget about this. Never forget about, right along with that, son might live with me for as long as I can, but I need to have a contingency plan in place. We'll have a contingency plan in place for your stuff when you're gone. The money's one thing. The bigger issue, in my opinion, is who's going to care for your son or daughter if you cannot? So nominating a guardian. This is who I want to care for. Remember what I said about the judge? Just kind of uses that as gospel. If mom and dad are gone and we introduce a will that says, I nominate sister to be guardian, the judge is going to say, yeah, that's who the guardian, as long as sister says, I'll be the guardian. So that's important.
Is that really necessary if you pretty much trust your family and that your uncle's going to do the right thing and just talk to him?
The the petition, whoever petitions for guardianship first, well,
Okay.
guardian needs to be appointed. So if you want sister to be guardian, but sister doesn't petition, uncle on the other side petitions, well, that's who the judge is going to appoint unless sister says, I want to do this. Okay. So,
But I mean, I would basically trust our family's pull to do it right, so.
one thing, I'm a
Your sister
paid
would
pessimist.
know any-
That's what folks
Nobody
pay me to
knows
do,
that.
is to see
You're a
the
lawyer, I understand.
Yeah.
Trust isn't in the language.
Yeah.
So what happens if nobody wants to take care of the kids? So if you're gone?
That is a possibility.
Yeah.
And it's unfortunate to me. There is a deep lack of guardians who are willing to serve for third parties that are willing to serve as such a guardian person.
So in that case, if, let's say you didn't prepare, too bad, right? That's not the best thing to do. Let's say if someone didn't, but lots of family on the flip side of what she said, want to take care of the kids, what does the state say? How do they pick someone? Is it your parent? I mean, let's say I passed away before Sam, go there, but let's say my husband and I got in a car accident tomorrow, and my parents want our kids, and my sister wants our kids, and, you know, who would get the kids?
Judges got a tough decision to make there, especially, I mean, if only one person petitions, and everyone can agree this is
Right.
the person.
Best case scenario.
But, if it's my sister and my wife's sister both saying, we're going to take their kids, it can be airing dirty laundry. I mean, it could be a rut. That's where nominating someone takes some of that away.
Do they ever
You know,
take the kids' voice into account in a situation like that too?
Yes, that's
Okay,
when they're,
that's what I
especially when
was
they're older.
thinking,
Over the age of 14,
Right.
especially, they'll ask the kids, they'll refer to the kid's decision. Over age 18, they'll ask the child what they're going to do. But if it's
Yeah.
Uncle Barney that he just they want to live there because he's fun and he loves to eat peanut butter for dinner and ice cream for lunch, you know, maybe you don't want him to go to
Right.
Uncle Barney.
That's why this is so important.
But if you had a guardianship and then you died, then what happens to the child then that was used to,
Still remains under guardianship. Someone else needs to be appointed as guardian. Okay? We actually have a relatively new law where the old guardian, similar to nominating, the old guardian can say, I want this person to serve as guardian until they get their petition in to be a permanent person. So there's no break whatsoever. You say, my sister's going to be guardian. So the day something happens, sister continues to serve as a guardian until the judge makes an assessment and says, yes, that's what we're going to do permanent. So that's part of your plan, is you have that document in place that says sister's going to be guardian. I want to hit on something that's more important though, and that is a letter of instruction. You know your child better than anybody else in the world. And appointing someone, even a close family member, as guardian is just the first step. They have an instruction manual, a guide to help them. It's going to make their role much easier. And here's what I mean by that. If your child doesn't like mustard on their sandwich, you better have that in the letter of instruction. My son has extreme sensitivity to his feet. If his shoes aren't just right, we're going to have a bad day at school. So that's a good thing to have. There's some other things I could think about here. Oh, who are his friends? Who are the medical providers? Who are those things? Who are bad influences? And that might be something you put in there. Just as detailed as you think that person needs to have. I use the mustard example. It was with one of my older clients, but he was demented and stopped eating, inexplicably stopped eating, and lo and behold, we found out that the facility was smearing mustard on everything they gave to him. He didn't like mustard. That's why he wasn't eating. Quit putting mustard on it, and he started gaining weight again, was doing just fine. So it seems trivial, but it really is important for guardian. Okay? With the money, and I'm not going to belabor these points a whole lot, but with the money, especially with families that might have a disabled child and then non-disabled children, how are you going to deploy those family assets? If you do nothing, Indiana's going to divide it for you. And Indiana's basically going to, there's one pot for each person. But maybe you want, I know that John can make his way in the world, but my other child, she's always going to be limited. I want to make sure we set a little bit extra aside for her. Making those decisions in your plan are important. Don't do this. Don't say, I'm going to leave it all to John, and John's going to take care of his sister for the rest of his life. It's not a knock against John. John could be the most stable person in the world, but one debilitating event hits him, and now all the family resources are wiped out. He could have a bad day at the job, and all of a sudden he's got a bunch of debts. He could become disabled. I mean, he could get in a car wreck and become disabled himself, and all these medical expenses, I've eaten up all those costs. He could die and didn't do his own plan, and it goes to his wife, who she's not going to take care of her sister-in-law for the rest of her sister-in-law's life. So, not a good idea. Well, what's a better way? Third-party special needs trust. Create your own special needs trust. Say, I'm going to put this money in trust for my disabled child. I'll appoint someone to manage that money. It's for them for their lifetime. At their death, then you can designate where it goes. Then it can go to the other sibling. But having that in place is important. I can't stress that enough, mostly because that's usually the first question I get is, why am I paying you this money for this trust when I can just give it to John and take it? Well, that's the major thing. Right back to, I'm sorry, I'm the paid pessimist. I have to look at the worst case scenario, and that could be the worst case scenario. Okay. And here's what these trusts can do. So I'm keeping Medicaid for my medical over here. I've got the SSI or other benefit that's helping bringing some cash in to pay for my food and shelter. I might have Section 8 housing, which we kind of glossed over that for anyone who is of financial need qualifies for Section 8 housing. And I have a lot of disabled individuals that get assistance through Section 8. It's usually rental assistance. And sometimes it's combined with a waiver, was provided in the waiver. Rental assistance help pay the rent. Waiver pays for the caregivers to come in, for example. I'm in a situation I've got a client, he's in an apartment with another disabled individual. They share the rent. They both have Section 8 housing, and caregivers come in regularly and check on them. Okay? All right. So the trust lets you keep these benefits, and I have a pool of funds that supplement those benefits. For big ticket items, the trust could purchase a home. I've had clients that are able to financially afford, buying a home for the children and maybe a couple of their friends or associates to be able to stay in one house. Can purchase furniture, can purchase transportation, equipment not covered by the Medicaid program or that might be superior to what's provided by the Medicaid program. Medicaid's going to go with the most cost-efficient method. I see this especially with wheelchairs, things like that. They're going to pay for this, but this is much better. Well, we've got the trust that can pay for it much better. Television, radio equipment. I updated my trust finally. I had record players in there for years. That's kind of maybe nostalgic, but I think iPods and so on are better. Going on trips, recreational equipment, but going to Disney World, traveling, things like that, the trust can pay for. Clothing, musical instruments, things that are of interest to the child. Sometimes we do use it to pay medical insurance because it's cheaper and better coverage to use the trust to pay a monthly health insurance premium than qualify for Medicaid and receive their services. And by the way, if the health insurance says, we're not going to cover you anymore, or something else happens, you've always got Medicaid as a backup because assets are in trust. Newspapers, magazines, care managers, outside third-party care managers, additional care outside of what's provided by Medicaid. I mentioned vacations, movies, travel expenses, legal fees, schooling, cleaning supplies. I had a disabled individual who was injured when he jumped in the pool, so he got a settlement, and we set up a special needs trust for him. But he was one that said, yeah, this is going to be for my schooling, and once I'm through school, I plan on working and having my own job and having my own independence. And so we set up the special needs trust, and it was just a short period of time, but allowed him to have Medicaid and other supports while he was at school. The trust funds helped pay for school, and then there was a little bit left over. He could buy his first house and then was able to get a job and support himself. So it was I really like that plan. Okay, and then other care that maybe Medicaid's not paying for is other special therapies. My wife is a pediatric physical therapist. She does hippotherapy and aquatic therapy, which very popular, but there's only so many hours that insurance and public benefits programs will pay for those services. Cleaning, home care, things like that. Airline travel, domestic travel. The trust can pay for shelter-related expenses, but remember the rule that you might get a reduction unless they're paying for something. Same rule applies to groceries as well. And what I usually say with that, especially from a Medicaid standpoint, if you want to buy, the trust buys $300 worth of groceries, just make sure that the child's using their Social Security to buy a gallon of milk at the same time. Then you're not buying all of the groceries. With SSI, you can get that third reduction because you're buying groceries, but one way around that is stockpile. Get your third reduction, buy $1,000 worth of groceries. That's going to cover you. Obviously, it's not fresh vegetables and so on, but canned goods, things like that. It's going to cover you for 3 months. So take your 1/3 reduction hit for 1 month, but then the next month you don't buy those groceries and you get your full benefit for the next 2 months. So there's some strategies to have there. I put clothing up there because Indiana's behind the times. Social Security several years ago said, we're no longer going to worry about clothing. If someone else wants to buy clothing, we're not going to reduce your benefit. Medicaid still has that rule that says if someone else buys your clothing, we're going to reduce your benefit by the value of the clothing. But the way around that again is buy a brand new suit, but make sure the child buys, or the recipient buys a pair of socks at the same time. Then resolve that. Okay. The one thing to never do, though, if your child's receiving public benefits, is to hand them cash, because cash is income. Income reduces or eliminates the benefit. And accumulated cash also becomes an asset and knocks them off the program.
So is that the same for like a 529 plan?
Meaning?
Okay, so if my kids, because my older kids have a 529, and then I've been thinking about, now that they're out of college, changing it over, because you change the beneficiary for the 529 plans. So probably I should give them the 529.
Good question. If it's a 529 you set up for them, it's your 529, your money. If you move it over to them, then it's their money.
Because it's mine, but they're the so like
They're the beneficiary.
So I tell them to send the check to the school, because it never goes to the kid, it always goes straight to the school.
But until that money comes out of the account, it's considered your money. So it doesn't affect their public benefits. State Medicaid director actually has more favorable than that. If you needed Medicaid, he says that 529 doesn't count towards your eligibility either. I don't think that's right, but that's their opinion. I'll take it.
Yeah.
If it's favorable to someone, I'm agreeing. So,
Now, we have a 529, but I put the beneficiary me. Does that affect in the future his public benefits.
So you're putting money in a 529.
Yes, but the beneficiary is me.
Well, the beneficiary is usually is the child, but if it's not used for education or something somebody happens to the child, then the beneficiary can't be you. It comes back to you. That might be what way it's set up.
Because he's under 18, that's the reason I put the beneficiary to this college fund is me.
I'd have to look at the detail. I mean, it might be on there just as his custodian until he turns age 18. But even at age 18, if you set that up and you own the account, then the money is still yours until you say it goes to his education expenses. Now, if you take it out for yourself, there's a penalty for taking it out, but you can still take it out at any time until it's used for his education.
Now, if we apply for the medical waiver, does the 529 college will affect his benefits? Maybe I should read it again.
If he's under age 18 and is not receiving, you said a waiver though, right?
Yeah.
Okay. So if he's under 18 and you own the account and he's receiving a waiver, then that account doesn't count against it because it's your asset. It's only available to him until you release the money out of it for him.
Right.
And that's why it's not available to him. That's why in her circumstance it's not available to her children until she says, I want the money to come out. Then it's a resource.
Now, the same thing with the trust expenditure. Is not cash available to him?
How the trustee handles expenditures, the trustee's buying things directly. So if the trustee's buying a new television set, the trustee either arranges with Best Buy to pay for it or will pay a credit card bill that's purchased the Best Buy television. That's the less favorable of the two. Usually it's I'm going to go to Best Buy, tell Best Buy I've got the trust, get the information from the trustee then writes a check to Best Buy
Got
and pay
it.
for it.
All right.
So it's always making payments directly to the vendor.
Yeah.
Because the minute you do, what you don't want to do is say, there's a $1,000 TV at Best Buy. Okay, well, here's $1,000 to go buy it. Well, Medicaid and Social Security just said, well, you just handed cash, which is income. We're going to count that and reduce the benefit.
Right.
But you can have your TV as long as you that check went directly to Best Buy.
Got you. Okay.
Any other question? I've lost. I don't know how much time I had allocated, so I don't want to keep you here longer than you want. But feel free to, I think I've looked through my materials anyway. If you have other questions, feel free to.
I have one question. We have a bill with a special needs trust bill being switched from the life insurance.
Okay.
One concern that I have is that I don't know how the will would be found if one of us were to die. My people know that it exists,
Okay.
but I don't necessarily trust them to, or I'd be able to find it when the time comes. Is there any kind of way you can register it or something like that?
Yes. I keep most of my wills in my vault. And I'm kind of that person, and then you just tell the family, call Jeff if something happens to us because he has it in his vault. And of course, I've got a surrogate, so if I get hit by a bus, we got somebody else that can get it. Two, if you just have it in a fireproof safe or so on, letting somebody know where it is. Three, there is a procedure where you can probate a will, you can put it on record with the court and say, here is the will. Now, the drawback to that is you've set that will into the record, and then if you want to change it, you've got a whole legal process to withdraw it and put in another one and so on. So, more practical approach would be put it in a safe place and let the most, maybe a couple of trusted individuals know where that is so that you can get to it if your attorney doesn't want to hold it to it.
I have a special situation with my kids because I follow these trust funds and my will and all those things, instructions, well, it's a lot. But it seems to me that if I die, really have don't have much family here in Indiana. So people that I would really trust to keep my kids in good shape live either in Canada or in Mexico. How does that apply if the mechanism actually kicks in because I die? Will these provisions still apply if the children need to relocate to Mexico or Canada?
I don't know. I don't know what these rules vary state by state, and I wouldn't even begin to know country by country. I mean, the trust is a trust here. My guess, though, is whoever's serving as trustee, if they move to a different country, is going to say, we want to get rid of this. We want somebody else to take it over. And frankly, I don't even know if Mexican law, Canadian law have trusts. I'm pretty sure Canadian does because they're based with the same legal system. They both come out of England and common law, but I don't know what Mexico is. I just don't know. Good question, though.
But still, the creation of the trusts and the financial resources will remain in India, right? Even if the children move out.
And they still be for the benefit of the children.
So the home base of the corpus of the resources will remain.
Mm-hmm.
So at least that's untouched.
Mm-hmm. As long as the trustee's willing to continue to manage it, even with them being someplace else, sure, it'll just stay here. I just don't know if that becomes an impediment to the trustee wanting to continue to do that work.
Me and my husband were thinking about like doing a trust account for our kids. Now, we have a special need kid and a typical kid. So how does it work with the trust? Do we make a special need a trust for one child, regular trust for another? Is that how it works?
Yeah. Because you have a disabled child, it's likely to need public benefits. I usually will do their trust separate, and then the other child could have a trust as well. And you could really put the other child's trust inside. You could have a primary trust with subtrusts that said this trust is for the family, for us, we control it, then with something happens to both of us, divide and distribute. And you could have them both subtrusts within that primary trust. I tend to like to have at least the disabled child's trust as a separate legal document, only because you send it to a non-legal trained staff member of a public benefits agency, and if they're looking at your primary trust and trying to sort through, well, what's the subtrust here? Well, what about this trust? It just gets a level of confusion that maybe you really don't need. So if you have a separate trust, you say, this is the trust for our disabled child. The primary trust said at our death, move money into this trust, and it has. Here you are, and then you don't have to worry about the trust for your minor child. It stays over here, and it's not any business of the public benefits agencies. That's just my general thought. You can do it any way you want.
So where do you have two special needs children? Do you have like separate trusts for?
If it's your money going into the trust, you can do it any way you can. It's really up to you. You can say, well, we want to keep this as a pot for my two special needs children to use as whoever needs the need. If one needs 3/4 of it, the other needs 1/4, it's up to the trustee. Or you can say, we're going to divide it into separate shares and have one master document dictate the separate shares, or they can have their own separate document. There's just that again, because of the confusion level, I generally refer to like the separate document. That way, one child's eligibility doesn't have an error because of this other child's information going to the same guy.